Good afternoon, everyone. Welcome to this lecture series on the rules on evidence. This afternoon, we will discuss about admissions and confessions. So let me share my screen. Okay. Rule 130, admissions and confessions. So sometimes, class, there is no more need to present evidence in court in order to prove the guilt of the accused. This is because either that the accused had admitted or has confessed to the crime charge of him. But admission and confession, class, is a technical term under the rules on evidence. They are different. No, they are not the same. So what is an admission? Admission is an act, declaration, or omission of a party as to a relevant fact which may be given in evidence against him. It is any statement of a fact made by a party against his interest or an unfavorable to the conclusion for which he contends or is inconsistent with the facts alleged by him. So when there is an admission, class, the party is declaring a fact against him. Okay? What are the requisites of an admission to be admissible in court? Number one, it must involve matters of fact and not of law. It must be categorical and definite. Third, it must be knowingly and voluntarily made. And number four, it must be adverse to the admitter's interests. What are the classifications of admission? Number one, it could either be express or when there is categorical declaration. It could either be implied, meaning it can be inferred from the declaration or acts of a person. An admission can be judicial or extrajudicial. When you say judicial, it is made in the course of a court proceeding, and extrajudicial outside the court. An admission can also be considered as an adoptive if it is a party's reaction to a statement or action by another person when it is reasonable to treat the party's reaction as an admission of something stated or implied by the other person. Let us compare admission and confession. Admission is a statement of fact which does not involve an acknowledgement of guilt or liability. On the other hand, a confession is a statement of fact which involves acknowledgement of guilt or liability. An admission may be made by a third person and in certain cases are admissible against a party. On the other hand, confession can be made only by the party himself and in some instances are admissible against. An admission can be expressed or implied, while confession is always in the express. So class, the basic distinction between an admission and confession is that in admission, the party is acknowledging a fact, but he is not acknowledging liability. On the other hand, in confession, there is an acknowledgement of both the fact and the liability of the confessor. What is a self-serving declaration? When does a declaration becomes self-serving? It is one which has been made extrajudicially by the party to favor his interests. It is not admissible in evidence because they are inherently untrustworthy and would open the door to fraud and fabrication of testimony. Now, offer of compromise, class, is not admissible in evidence. Ano ba yung mga offer of compromise, class? No? What are these offer of compromise? Offer of compromise, class, usually in, for example, in road accidents, no? In a prosecution of cases of reckless imprudence resulting to damage to property, for example, now when the erring party or the guilty party will offer to pay, now the victim or the family of the victim, for example, this offer to pay or offer of compromise in civil cases is not an admission of any liability and is not admissible in evidence against the offerer. So if a party to a road accident will offer to pay the victim or the injured party, then that offer is not admission of liability against the offerer. Now, in criminal cases, except those involving quasi-offenses or criminal negligence, or those allowed by law to be compromised, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. So as a general rule in criminal cases, if one party, for example, the accused, will offer to compromise the case, no, to pay the private complainant so that the case will be withdrawn, then that offer of compromise made by the accused may be received in evidence as impliedly admitting his guilt. And the exception in criminal cases is those cases involving quasi-offenses or criminal negligence. For example, the one that I gave you, reckless imprudence or simple imprudence. Now, what about if a third party has made the admission? No? Admission by a third party or the res inter alios acta rule. Now, the rights of a party cannot be prejudiced by an act, declaration, or omission of another. This is the definition or translation of the res inter alios acta rule. The rights of a party cannot be prejudiced by an act, declaration, or omission of another. What are the exceptions to the res inter alios acta rule? One, admission by a co-partner or agent. Now, in a contract of partnership, if a partner, if the managing partner or the industrial partner or the capitalist partner will make an admission, then that admission by such partner is binding to the other partners or to all partners for that matter. Likewise, class, if the agent has made an admission, that admission by the agent is binding to the principal. Also, number two, admission by a co-conspirator. You learn this in your criminal law 1. In case of conspiracy to commit a crime, no? The admission by a co-conspirator acting under one criminal design will be admissible in evidence as to that of the other co-conspirator. And number 3, admission by privies or those who are privity or those who are with privity of contract. Let us go to an admission by a co-partner or agent. What are the requisites? 1, the act or declaration of a partner or agent of the party must be within the scope of his authority. Number 2, during the existence of the partnership or agency. And number 3, after the partnership or agency is shown by evidence other than such act or declaration. What about the requisites for admission by a co-conspirator? Number one, the declaration or act must be made or done during the existence of the conspiracy. Number two, the declaration or act must relate to the conspiracy. And number three, the conspiracy must be shown by evidence other than the declaration or act, or what we call as evidence aliunde. Number three is admission by privies. Requisites: one, there must be privity between the party and the declarant. Number two, the declarant, as the predecessor in interest, made the declaration while holding the title to the property. And number three, the admission relates to the property. What about admission by silence? I think you are all familiar with this one. Diba? Sometimes, if somebody asks you, pag may nagtanong sa inyo, no, when you are during your elementary days, you remember when your classmate will ask you something and you did not confirm nor deny the question. Sasabihin sa inyo, uy, guilty yan, di ba? Ibig sabihin, that is admission by silence. Because that silence is considered as a yes answer. Di ba? Ang sabi nga nila, silence means yes. That is also true as in the rules on evidence. Admission by silence is where there is admission by silence when a party does or says nothing, when he hears or observes an act or declaration made in his presence, when such act or declaration is such as naturally to call for action or comment if not true, and when proper and possible or for him to do so. Such may be given in evidence against him. So sometimes, class, di ba, you will hear something, no, an information, and that information naturally impels you to act or give your comment if not true. Then, if you did not give your comment or if you did not make an action despite hearing such information, then that is what you call as admission by silence. For example, in the prosecution of BP 22, the payee of the check will go to the drawer, and then the payee of the check would say that the check bounced because it was closed due to it was bounced due to insufficiency of funds. So if the payee of the check will come to X, for example, and he showed the check with stamp drawn against insufficient funds, or DAIF, and that person did not confirm nor deny that the check had actually been bounced due to insufficient funds, then what is the inference? That is admission by silence. No? That person may not deny that he is not the drawer of the bank, or not, sorry, the drawer of the check. Because if you are not the drawer of the check and a check was shown to you by the payee, and that the check is a bouncing check, and he is requiring you to make good of the check, but you did not confirm nor deny, diba? That presentation of check will naturally impel you to act or comment if not true. Then there is admission by silence that that person whose check was presented is admitting that he is the drawer of the check. Because otherwise, if you are not the drawer, it will naturally impel you to act or comment. Huh? So that is what you call as admission by silence. What are the requisites of admission by silence? First, he must have heard or observed the act or declaration of the other person. Second, he must have the opportunity to deny it. 3, he must have understood the statement. 4, he must have an interest to object such that he would naturally have done so if the statement was not true. 5, the facts were within his knowledge. And 6, the fact admitted or the inference to be drawn from his silence is material to the issue. What about confession? What are the classifications of confession? Confession can be judicial. It is made during the course of a trial, or extrajudicial. It is made out of court. Now, it cannot be sustained. Extrajudicial confession cannot sustain a conviction unless corroborated by evidence of corpus delicti. Ano ba yung corpus delicti class? Body of the crime. So if the accused has made an extrajudicial confession, meaning the accused has acknowledged the fact of commission of the crime and his liability thereto, that confession made out of court cannot be sufficient to sustain a conviction. Dapat meron siyang coupled with evidence of corpus delicti or body of the crime. What are the requisites for a confession to be admissible in evidence? 1, it must involve an express and categorical acknowledgement of guilt. 2, the facts admitted must be constituted of a criminal offense. 3, it must have been given voluntarily. 4, it must have been intelligently made, the accused realizing the importance or legal significance of his act. And number 5, there must be no violation of Section 12, the Miranda Rights, Article 3, Bill of Rights of the Constitution. Okay. Extrajudicial confessions. As a general rule class, an extrajudicial confession is not admissible against the confessor's co-accused. Such confession is hearsay evidence and violative of the res inter alios acta rule. So for example, there are 3 accused in the case, and that one of the accused had extrajudicially confessed the crime. He has acknowledged the commission of the crime and his liability thereto. As a general rule class, the extrajudicial confession of a co-accused is not admissible in evidence against the co-accused. No, it is violative of the res inter alios acta rule, and it is considered as hearsay. There are certain exceptions. It may be admitted in evidence against his co-accused in the following cases. Number 1, in case of implied acquiescence of the co-accused to the extrajudicial confession. For example, the accused, while confessing to the media or to a news reporter, for example, the other co-accused nod his head. So when the other accused, in the act of nodding his head, while his co-accused is making an extrajudicial confession, such implied acquiescence will result to the extrajudicial confession binding him. Okay. Number 2, in case of interlocking confessions. Number 3, for the accused admitted the facts stated by the confessant after being apprised of such confession. Number 4, if they are charged as co-conspirators of the crime, which was confessed by one of the accused, and said confession is used only as corroborating evidence. 5, when the confession is used as circumstantial evidence to show the probability of participation by the co-conspirator. 6, when the confessant testified for his co-defendant. And number 7, when the co-conspirator's extrajudicial confession is corroborated by evidence of record. What is the doctrine of interlocking confessions? It states that the extrajudicial confessions independently made without collusion, which are identical with each other in their essential details, are corroborated by the other evidence against the persons implicated, are admissible to show the probability of the latter's actual participation in the commission of the crime. Okay? What about previous conduct as evidence? For example, class, a criminal complaint was filed for estafa. And then the evidence presented by the prosecution is that previously there was an estafa case that was filed against the same accused and that the accused was convicted thereof. Can that previous case or previous commission of estafa be admitted in evidence to prove the present case of estafa? No, that is the question. Now, similar acts as evidence res inter alios acta rule, part 2. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he did or did not do the same or similar thing at another time. But it may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom, or usage, and the like. So as a general rule, class, similar acts may not be admitted in evidence that a person has committed or has not committed an act, no? Subject to certain exceptions. The previous acts, the previous similar acts can be used as evidence to prove the specific intent of the accused, or for example, the identity of the accused, or the scheme or the habit, custom, usage, and the like. Okay? The rule prohibits admission of the so-called propensity evidence, which is evidence that tends to show that when what a person has done at one time is probative of the contention that he has done a similar act at another time. Evidence of similar acts or occurrences compels the defendant to meet allegations that are not mentioned in the complaint, confuses him in his defense, raises a variety of relevant issues, and divert the attention of the court from the issues immediately before it. So class, yung propensity, for example, is the accused, does the accused have has a propensity to commit the crime of estafa? No, that evidence it is not admissible in court. What about unaccepted offer? An unaccepted offer is an offer in writing to pay a particular sum of money or to deliver a written instrument or specific personal property, no, if rejected without valid cause, is equivalent to an actual production and tender of the money, instrument, or property. Okay, so this ends our discussion. I'll see you again next meeting.